health in my office with his work on criminal procedure and the Bill of Rights, and he has, as I indicated earlier, most recently published America's Constitution, a biography, and he has kindly agreed to speak to us this afternoon. So, Professor Amar.
It is such a pleasure and a privilege to be with you here. Thank you for the weather. The lack of wind on the tarmac last night was much appreciated. So I'm going to give you a history lesson today about the Article III judiciary, and with apologies in advance, I'm going to read some portions of a chapter that I wrote called Judges and Juries. Let me identify, before I begin the reading, four or five of the maybe modern-day implications or the larger lessons, I think, that come from this historical narrative. And then I'll, after I finish the reading, I'll give you the sting in the tail, one perhaps counterintuitive thought that emerges from this history lesson. So the story you're going to hear is a story about how the third branch of the Supreme Court and the Judiciary really were at the founding the third out of three branches, much less powerful at the founding than the 800-pound gorilla into which the branch the Judiciary has grown. You'll hear an account of why, over the next 200 years, that growth occurred, an account about the difference between judicial review of Congress and judicial review of the states, and an account about the very exquisite balance between a highly politicized, by intent, process of appointment and more independence vesting at the magic moment of judicial installation, which we heard about this morning, in fact. Here goes. Modern civics textbooks portray America's Supreme Court as the ultimate interpreter of America's supreme law, first among the branches in the art of constitutional interpretation. The Constitution itself presents a more balanced picture, listing the judicial branch third, pronouncing the justices supreme over other judges, but not over other branches, and installing juries alongside judges. The founders surely hoped that the judiciary would do its part to protect the Constitution, but just as surely they knew that much of the document's success, democratically and geostrategically, would depend on men other than life tenure judges. So why would that be so? And here's the story. When leading colonial lawmakers and soldiers spearheaded the drive for independence in 1775 to 76, few prominent colonial judges stood with them in the vanguard. And this is because of a general truth. Judges are in general, well-fed characters who defend the status quo. Although elected patriot leaders did their best to influence the judicial selection process in the mid-18th century, imperial officials generally retained the right to appoint and remove American judges. In 10 of the 13 colonies, the sitting Chief Justice or his equivalent ultimately chose George III over George Washington. So I think that's a pretty significant fact that helps give you a sense of what the judiciary is seen as at the founding. Connecticut and Rhode Island, where colonists named their own judges, mark the main exceptions to this pattern. Putting aside continental congressmen from this pair of states, only 3 of the other 50 men who signed the Declaration of Independence had held notable positions on the colonial bench. In virtually every revolutionary state constitution, the legislative and executive branches received more overall power and far more textual elaboration than the judiciary. Only in Massachusetts did the Constitution feature 3 separate articles, they call them chapters, for the 3 main branches of government. Even this document treated the judiciary last and devoted to it only a fraction of the space spent embellishing the legislature and the executive. No state constitution explicitly authorized courts to disregard duly enacted statutes that the judges deemed unconstitutional. Now, by 1787, the American judiciary had begun to rise in repute. Patriots now peopled state courts everywhere. 6 of the Constitution's 39 signers had already served as prominent state or continental judges, and several others were obvious prospects for appointment to the new federal judiciary on the drawing board. As the new system actually took shape, Philadelphia framers received 3 of the 6 appointments that Washington made to the Supreme Court in 1789 and filled 2 of the 5 court slots that opened up later in his administration. Washington also tapped 2 fellow Philadelphians to serve among the first 13 district court judges in 1789. And by comparison, Philadelphians made up 11 of the 22 senators elected in 1789, so half of your senators, 8 of the initial 59 House members, and 2 of the first 5 cabinet officers. The Constitution proposed by the drafters gave federal judges more power and independence than their state counterparts commonly enjoyed. Yet even this document listed the judiciary last among the branches. The textual order of the Constitution's first 3 articles made both conceptual and democratic sense. Laws would first be enacted by the legislature and then implemented by the executive. Only at that point might the judiciary appear if the executive commenced civil or criminal prosecution or a private party brought suit claiming some legal violation. Also, in the new Constitution's first months, the budding branches would need to materialize in precise sequence. First, the new Congress would meet to count the ballots cast by the presidential electors. Only then could an executive be installed, after which the first 2 branches could begin structuring the third, deciding the size and shape of the Supreme Court, the contours of the lower federal judiciary, and so on. Once these general decisions were made, President and Senate would begin appointing individual judges. This specific 1789 sequence tracked a more general democratic logic, in which the institutions mentioned earliest in the document rested on the broadest electoral base. First came the pyramid's immense foundation, an extraordinary act of constitutional ordainment by the people themselves via the preamble. And in an earlier chapter, I show how in that preamble election, special ordinary property qualifications were actually waived in 8 of the 13 colonies, so that people who ordinarily couldn't vote or run for office were allowed to vote and run for convention delegates. So that was an extraordinary act of popular participation by the standards of 1787 in the preamble. Then came the next broadest level of popular input, Article 1, in which ordinary voters and state legislatures would select congressional public servants. At the next, Article 2 tier, voters, state lawmakers, and Congress members would interact to choose the president. In the final stratum, Article 3, voters and state legislatures would fade from view as the men they chose for the first 2 branches made the major choices. Democratically, Congress ranked first among equals, and the life-tenure judiciary, furthest removed from the people in the states, came last. To see the big picture from another angle, begin by noting how the Constitution in various places empowered legislators and executives to pick other legislators and executives. State lawmakers would elect federal senators. Each congressional house would choose its leaders. State legislatures could select presidential electors themselves, or let the voters do so. Congress would break electoral college deadlocks. This is pre-Bush v. Gore. State governors would tap men to fill temporary Senate vacancies, and presidents would name their cabinet subordinates, unilaterally in cases of temporary vacancies and with the Senate's approval in other cases. The Constitution also empowered legislators and executives to select judges, with Congress determining the number and type of judicial slots to be filled by the President and the Senate. Nowhere did the document symmetrically empower judges to name legislators or executives. Again, that's why Bush versus Gore seems so discordant to people. Or even other judges. You could imagine a system, of course, and some Europeans have it, where judges, in effect, pick other judges. Just the way faculty members pick other faculty members in a kind of self-perpetuating regime. But we didn't do that. State legislatures and state governors would help decide who would hold federal positions, but state judges would not. While representatives and senators would choose the House Speaker and the Senate leader, respectively, federal judges would have no say in the selection of the Chief Justice. Nor would lower federal judges have formal input in selecting Supreme Court Associate Justices. The Constitution guaranteed the President's right to hire and fire his cabinet subordinates, but failed to guarantee any Supreme Court role in the appointment or removal of lower court judges. While each congressional house could cleanse itself by expelling members who misbehaved, neither the Supreme Court nor the judiciary as a whole enjoyed comparable inherent power to clean the judicial house. Congress could impeach and remove judges, yet judges lacked counterbalancing authority to oust congressmen. In all these ways, implicating the essential power to fill up and empty out the branches, the judiciary was not just last, but least. True, Article 3 featured a court that it called supreme. But this adjective hardly meant that the judiciary outranked the legislature and the executive. Rather, the word primarily addressed the hierarchy within the judiciary itself, placing America's highest court above any lower federal courts that might be created. Thus, each of Article 3's first two sentences juxtaposed the Supreme Court against other inferior federal courts, as did earlier language in Article 1, empowering Congress to, quote, constitute tribunals inferior to the Supreme Court, unquote. Yet even this Supreme Court was given rather few constitutional tools to keep its underlings in line. Apart from its power to reverse or affirm lower court decisions via rulings that all inferior tribunals were honor-bound to follow, and maybe by the canons too, the Supreme Court had little inherent power to punish insubordinate deputies or reward loyal ones. While a president typically had several practical ways of disciplining his executive inferiors, his cabinet officials, the Supreme Court had no automatic authority to change a lower court judge's work assignments, affect his pay, or modify his title. In some ways, Article 3 judges were almost as independent of one another as they were of the other branches. An early draft from Philadelphia had proposed creating one or more supreme tribunals. Several colonies had actually structured separate judicial tracks for different types of legal proceedings, with some revolutionary states continued this pattern. But in contrast, the Article 3 envisions one Supreme Court with simultaneous appellate authority over law, equity, and admiralty. Nevertheless, Congress, under the Necessary and Proper Clause, had considerable power to decide just how unitary this one court would be as a practical matter. For example, whether and when the justices would be obliged to sit in specialized smaller panels rather than as an en banc collective. So Congress has chosen, really, to structure a more pyramidic Supreme Court than perhaps it had to. I then talk a little bit about the origins of judicial review, and I say that it is contemplated in the Constitution. Publius does say, of course, in the Federalist 78, that federal courts would refuse to enforce federal laws that were, quote, contrary to the manifest tenor of the Constitution, unquote. Now, I give you a couple of just as little facts to remind you that, of course, between the entire period between 1789 and 1850, although the court would invalidate more than 30 state statutes, there's only one invalidation of an act of Congress. That's a tiny sentence buried in a sprawling statute, and that sentence, of course, regulates the technical issue of judicial procedure, and that case, of course, is Marbury, and you'll hear a little bit more about Marbury. So the real question is, how manifest did a constitutional impropriety have to be so as to justify judicial regard of a duly enacted congressional statute? That's the question of presumption of constitutionality that you heard discussed this morning. Would federal judges void a federal statute if the constitutional issues were fairly debatable? Or would they act only in a case if a case involved a particularly egregious violation or an issue that's specially related to judicial procedure, like jurisdiction in Marbury? Though nothing in Article 3's text explicitly addressed this precise point, the Constitution's general structure hinted at a rather modest judicial role. And let me also just, by the way, tell you, in an earlier chapter, I've told the reader that against this one act of judicial review prior to 1850, there are about 24 times when presidents refused to sign laws on constitutional grounds, and almost always on constitutional grounds that actually the courts would not necessarily have used as a basis for legislative invalidation. So in this early period, the branch that's really enforcing the Constitution most against the legislature, against Congress at least, isn't the federal judiciary, but the President of the United States, the unitary executive, which has taken a beating of late. George Washington thought that he was the unitary executive, by the way. George Washington thought he was a unitary executive. I know you asked about Alito and he didn't answer, but George Washington believed in a unitary executive, and he looked in the mirror and said, "That's me." Okay. So here are the structural arguments for a rather modest judicial role. This is kind of historical evidence for maybe not quite the taking the Constitution away from the courts altogether, a la Tushnet, but a modest Thayerian, perhaps, judicial role. In tandem with the Article I necessary and proper clause, Article III left the Supreme Court's size and shape up to Congress and the President via the veto, while Article I expressly empowered each congressional house to determine the rules of its internal proceedings and authorized the houses jointly to decide when and where to meet. Article III gave the judiciary no comparably broad grant of institutional autonomy. Congress, not the court, would have the upper hand in deciding how, when, and where the justices would sit, what rules of procedure they would follow, and so on. Although the Constitution shielded individual judges against politically motivated salary cuts and attempted removals, it left the court as a whole open to political restructuring. For example, the political branches could detour around an obstinate court majority by expanding the size of the court, appointing new justices more likely to defer. Now, of course, such efforts to pack the court could fail if American voters opposed the plan. But that just shows that the court really wasn't supreme over Congress, but that all the branches really were subordinate ultimately to the people. Unlike Congress and the President, state governments would have no formal say in determining the court's general contours or making specific decisions about whom to put on it or pull off it. A state whose laws were declared unconstitutional could detour around the existing justices only by convincing the other federal branches that its grievance had merit. Thus, the constitutional structure emboldened the court to vindicate national values against obstreperous states, even as it cautioned the justices to avoid undue provocation of Congress. And that is John Marshall's court. He basically is beating up on the states and siding with Congress in the main. In fact, Congress had many weapons to wield or at least brandish against the justices if it so chose. The legislature enjoyed vast discretion to grant or withhold judicial pay increases, to fund or deny judicial perks and support staff, to reshape the inferior federal judiciary, even strip the court of jurisdiction in some cases. Now, though the court might try to resist some of these aggressive tactics, the justices had far fewer defensive weapons than did a president. Who had a fixed 4-year salary. You can't increase or decrease the president's salary, so you can't sort of dangle before him pay increases the way you can before the judges. Judges can disregard a duly enacted law that weakens their branch only if they can, with a straight face, say it's unconstitutional. A president can veto it merely on the grounds that it weakens his power, or for any other reason he sees fit to give. Against the backdrop of frequent and highly visible gubernatorial vetoes in the colonial era, the Constitution carefully specified the procedures to be followed whenever the president sought to veto a congressional bill. Yet the document failed to specify comparable procedures to be followed when judges sought to avoid Congress's output, a small but telling sign that the founders, with little actual experience with judicial review, did not anticipate that the judicial negative would one day surpass the executive negative as the main check on Congress. For example, in the case of a veto, the Constitution specifies that each presidential negative needed to be accompanied by the executive's objections, which would then be immediately entered on the journal of the originating House. The document further required that congressional override votes shall be determined by the yeas and the nays, with the names of persons voting for and against it entered on the journal of each House, which have to be published on a regular basis. By contrast, nowhere did the document require each individual justice to give his yea or nay on the constitutionality of a federal statute or any other issue. Under the Marshall Court, dissenting justices did indeed sometimes fail to publicly register their disagreement with the court's ruling. Nor did the Constitution require immediate publication of judicial opinions that would set congressional statutes at naught, or even the issuance of written opinions in momentous cases. In the 1790s, justices routinely delivered oral opinions in the courtroom while offering up no written statement of reasons to the broader public. Timely publication of the justices' reasoning did not reliably occur until the 18-teens. Even more telling was the judicial article's silence on issues of judicial apportionment. The precise apportionment rules for the House, Senate, and presidential electors appeared prominently in Articles 1 and 2. These rules reflected weeks of intense debate and compromise at Philadelphia and generated extensive discussion in the ratification process. Yet Article 3 said absolutely nothing about how large and small states, Northerners and Southerners, Easterners and Westerners, and so on, were to be balanced on the Supreme Court. This gaping silence suggests that the founding generation envisioned the court chiefly as an organ enforcing federal statutes and ensuring state compliance with federal norms. That's John Marshall's court. Just as it made sense to give the political branches wide discretion to shape the Postal Service, the Treasury Department, or any other federal agency carrying out congressional policy, so too it made sense to allow Congress and the President to shape the federal judiciary as they saw fit. If, conversely, Americans in 1787 conceived of the court not as a faithful servant of House, Senate, and President, but rather as a muscular overseer, regularly striking down federal laws as a fourth chamber of federal lawmaking, it's rather hard to explain why the document gave the first three chambers virtually plenary power over the fourth's apportionment. And by the way, if you want to know why the Dred Scott case comes down the way it does, the answer is the Supreme Court is hugely malapportioned by then. The South has the South is I'll get to it. Okay, with no constitutional guidance or constraint, the political branches in antebellum America ultimately structured a court that leaned south, just as Congress and the presidency themselves tilted in that direction thanks to the 3/5 clause. And I've earlier shown how the 3/5 clause creates a very pro-slavery presidency and a very pro-slavery Congress. Without the 3/5 clause, John Adams wins that election against Thomas Jefferson. Because Adams wins the northern states, Jefferson wins the southern states, the 3/5 the margin of victory. When not in the Capitol participating in Supreme Court cases, each justice would be responsible for hearing lower court cases within his assigned geographic circuit. Antebellum Congresses drew the boundaries of these federal circuits with attention not merely to the underlying litigation population to be served and the caseload to be carried, but also to the number of square miles to be crisscrossed and the condition of the roads to be ridden. With its rural expanses and poor highways, the South won a far larger share of judicial posts than its underlying free population warranted. By the time of the Dred Scott case, slave states with less than 1/3 of the nation's free population claimed 5 of the 9 judicial circuits, and thus a clear majority of Supreme Court seats. In its Judiciary Act of 1789, the first Congress created a 6-man Supreme Court. From a modern perspective that views court opinions as the unique last word on constitutional meaning, the number 6 might seem highly dysfunctional. After all, if the justices tied 3-3, the country would lack definitive guidance from its anointed oracle. But at the founding, an even number was not so odd. The 18th century Supreme Court was merely the highest judicial tribunal deciding individual cases. In the event of a tie, the status quo would continue. So in an appeal, the litigants would live with the result reached below, and if the justices were sitting as a trial court, plaintiff would just lose his bid for relief. In an 18th century system, each justice would typically offer his own reasoning and speak only for himself, as judges customarily did in England and the States in 1787. No collective court opinion would presume to be the last word. Only under Marshall did the court begin to speak with one voice, and not until the 20th century did the court begin to describe itself as the ultimate interpreter of the Constitution. Most of the constitutional controversies that flared up in the Republic's first dozen years never came before the pre-Marshall Supreme Court. For example, did the president have a unilateral right to remove cabinet officers in whom he had lost confidence? Could the federal government assume state Revolutionary War debts? Might it create a national bank? In apportioning Congress after a census, what sort of mathematical rounding practices were permissible? And I give like 8 other big issues, and the courts weigh in on none of them in the 1790s. Here's one of them. How should the naughty presidential election of 1800-1801 be untied? You see, you don't have Bush versus Jefferson versus Adams, or Jefferson versus Burr in 1801. Some of these constitutional controversies presented political questions well outside the purview of 18th century courts. Others involved lawsuits in which the Supreme Court lacked statutory appellate jurisdiction. The Sedition Act cases never come before the court because the Supreme Court lacks general appellate power to review federal criminal law cases decided by the lower federal courts. So the Supreme Court gets the biggest constitutional issue that they really get involving a congressional law is about a carriage tax. And the Supreme Court unanimously upholds it, just deferring to Congress. Now, how do we get from that, that's the picture, to what we've got today? And here's my quick story on that, and then a little bit on good behavior. And so, over the next 2 centuries, several factors would conspire to exalt the court's absolute and relative position. In the system's first 100 years, as new states entered the Union and Congress periodically redrew circuit lines, the court's size fluctuated from 5 to 10 members, and that fluidity made court packing easier to accomplish or at least threaten. But eventually the frontier closed, circuit riding ended, the court's size stabilized at 9. Inertia begins to take hold, certain political levers start to rust up, and even a popular president, Franklin Roosevelt, in the afterglow of a triumphant re-election, encounters stiff opposition to his 1937 court packing plan. At the other end of the judicial hierarchy, and I think here's a very key fact, the mushrooming number of federal statutes on the books has required an ever-increasing number of lower federal court judges to manage all the resulting issues arising under federal law. This vastly broader base of lower court judges has in turn given the High Court that many more inferior federal officers to order around, officers who, by both constitutional command and professional training, have generally seen themselves as the court's lieutenants. Now, here's the key fact. In its earliest judiciary acts, Congress created 15 federal district court judgeships. That's 1 for every 7 representatives, members of the House of Representatives. 1 judge for 7 congresspersons. Today, there are nearly 1,000 lower federal court judges, 2 for every House member. So that ratio of Article III judges to Article I representatives has increased 15-fold. And so today, my students, your students, are far more likely to work for a judge than they are to work for their local congressperson. And a large federal judicial corps has blunted 2 of the major advantages enjoyed by federal legislators at the founding: sheer numerousness and personal connectedness to ordinary citizens. Improved reporting practices have enabled the court to get its message out and quickly. Nowadays, there's typically a single opinion of the court. Meanwhile, a partisan and crumbly Congress, not crummy, but crumbly, maybe crummy, has often found it hard to speak with one voice. Presidents have come to be seen as party politicians rather than impartial magistrates, not quite like Washington, Jefferson, Adams, Madison at all. As the court has asserted more power for itself, the other branches in the citizenry have frequently yielded. At the turn of the 20th century, Congress gave the court sweeping power to review lower federal court rulings and greater bureaucratic control over the judiciary as a whole. They didn't have inherent power, but Congress gave them a lot more power over their branch. Today, there are no important pockets of federal law over which inferior courts can rule without being subject to direct reversal by the Supreme Court. At the founding, the prestige and power gap between 6 Supreme Court justices and 15 federal district judges, and they're all kind of sitting together often in these circuit courts, that difference was much smaller than the gulf that now separates 9 justices from the 1,000 lower federal judges. So even as the third branch has risen vis-a-vis the other 2, the Supreme Court has risen vis-a-vis the lower federal bench. Also, Congress in the early 20th century gives the Supreme Court vast discretion over its appellate docket. Today it has near plenary authority to define its own agenda, a luxury once possessed only by the political branches. Decades of divided government have pitted presidents against Congress, enabling the court to draw more power to itself at minimum risk of political reprisal, because if the other branches can't agree on anything, you can do a lot of stuff and you're not going to get overruled. After Vietnam and Watergate, much of the public has come to view the judiciary as more honest and competent than the politicians in the other branches. The courts see themselves and are seen by the public as the heroes of Watergate and Vietnam, with the Pentagon Papers case and United States versus Nixon, for example. Modern presidents and congressmen are far less likely to assert their constitutional visions than were their antebellum predecessors. For example, almost every president prior to the 20th century talked about the Constitution in his inaugural address. Today, presidents rarely do. Only a small percentage of veto messages today talk about the Constitution. Almost more than half of the early vetoes by presidents were explicitly constitutionally based. Today, President Bush will sign the campaign finance bill into law saying, you know, there's some really serious constitutional problems here. Good thing there's a Supreme Court. That wasn't Washington. Okay. That George was different than this George. Finally, at the highest level of American lawmaking, the nation has approved one constitutional amendment after another with the increasing expectation that litigants may come to court to define and enforce their constitutional rights, even against Congress. Thus, Article 3's small s Supreme Court has become modern America's capital S Supreme Court. So you read the Constitution, it's Supreme Court with a small s. Okay, I'm just going to skip ahead a little bit and tell you just a little bit about this idea of tenure for good behavior, what that is all about. And in a nutshell, it's an openly political process. Let me give you some data on this. Just what's happening today is nothing new. The Constitution allowed the President and the Senate to consider political and ideological factors in selecting Supreme Court justices and lower court judges, and such variables did, in fact, figure prominently in early appointments. Every one of the 8 men to sit on the Supreme Court before 1796 have been a highly visible Federalist in 1787 to 88. Half the country is Federalist, the other half is anti-Federalist, basically, and Washington picks only from his side of the aisle. The first former anti-Federalist whom Washington named to the court, Samuel Chase, did not win the president's favor until Chase had shown himself to be a strong post-ratification supporter of the president's administration. So like a Zell Miller crossing over or a Jeffords or something. That's what's going on. Of Washington's 16 initial nominees to the district bench, 9 had publicly supported the Constitution in their respective ratifying conventions. Several others had demonstrated the commitment to the Federalist cause in other ways. Conversely, none had voted against the Constitution in state conventions. After Washington's departure, openly partisan competition heated up in the federal legislative and executive races, and federal judicial politics followed suit. John Adams sought to stuff the bench with fellow Federalists, Jefferson with fellow Republicans. In 1810, ex-President Jefferson tells his friend James Madison not to appoint Joseph Story because Story was, in Jefferson's view, unquestionably a Tory who, as a congressman, had deserted Jefferson on the administration's embargo policies. Now, in the end, Madison names Story, who says, and this is a quote from Story, "I was a, quote, decided member of what was called the Republican Party, and of course a supporter of the administration of Mr. Jefferson and Mr. Madison, albeit a Republican of independent judgment and not a mere slave to the opinion of either president." Now, this sounds a lot like Alito when he's he's trying to, say, I'm a member of this, I'm part of your coalition. Of course, I'll be a judge, but not until Republican Abraham Lincoln named Democrat Stephen Field would a president openly reach across party lines in a Supreme Court nomination. And when Lincoln did so in 1863, of course, the deepest ideological divide ran not between Republicans and Democrats, but between Unionists and secessionists. Remember that in 1864, Lincoln's going to name a war Democrat, Andrew Johnson, as his running mate. From its earliest days, the Senate, in its confirmation process, felt free to consider the same broad range of factors that a president might permissibly consider in his nomination decisions. For example, senators in 1795 voted down John Rutledge for Chief Justiceship, largely because they doubted his political judgment. So they're saying no to George Washington. They're saying no to George Washington on largely political grounds. He's permitted to take politics into account, so are they. The judicial article thus provided for an openly political and ideological process of initial appointment. Presidents and senators could not properly extract promises from judicial nominee, but were free to indulge in predictions about how the nominee might rule and to factor such predictions into their appointments calculus. Now, once you're in power, of course, you have this tenure for, once you've been confirmed, for good behavior. And I talk, and I'm going to sort of skip over some stuff here, about how that's a new idea compared to the states, in that none of the states had the precise package of executive appointment and good behavior and undiminishable salary and no legislative removal by address. So all the states in England had one or another lacked at least one of those features. So a stronger federal judiciary than ever before. But still, there are loopholes. Once a federal judgeship has been created, can it be eliminated? This is what happens, of course, with the repeal of the midnight judges. So what happens in that? I'll just tell you just a little bit about that and then come to a close. In 1801, a lame duck and electorally repudiated Federalist Congress created a row of new federal judgeships, which President Adams proceeded to pack with Federalists in the closing hour of his administration. Unamused, President Jefferson and his Republican allies in Congress took action in 1802 to oust these judges en masse by simply repealing the 1801 law that had created the judgeships. None of the ousted judges had been adjudged guilty of any misbehavior, and a simple legislative majority had sufficed to enact the repealing statute. In effect, if not name, this was removal by address. Nevertheless, when the issue reached the Supreme Court in Stewart v. Laird in an 1803 companion case to Marbury v. Madison, the court yielded to the new Congress's force majeure and fait accompli. In this early judicial capitulation, we glimpse yet again the weakness of the early judiciary when confronting a united legislature and executive. Nowadays, Marbury is customarily the first case assigned in a law school course on the Constitution. Most lawyers, indeed many law professors, have never heard of Stewart versus Laird. Okay, so fess up. How many people knew of Stewart versus Laird? Raise your hand. Okay, not so many. That's the far more important case in 1803 than Marbury v. Madison. But in the early 19th century, the trivial statutory section that the court struck down in Marbury paled in significance to the prominent provisions that the court felt obliged to uphold in Stewart. For all Marbury's bold notes, John Marshall was sounding his judicial trumpet in retreat. In a variety of ways, then, the judicial tenure doing good behavior did not wholly remove judges from the ebb and flow of larger political currents. And here's this last point that I want to make, the sting in the tail. Indeed, and basically just the point is going to be that Article 3 is sometimes seen as the model of judicial independence as compared to states. But in one respect, maybe the states have it right. Maybe foreign governments have it right. Mark Tushnet's work and Vicki Jackson's on comparative constitutional law is quite interesting here. But let me give you the data. Indeed, the very open-endedness of tenure for good behavior may well have inclined many an early federal judge to think politically about his judicial exit strategy. That is, about a possible political career after his time on the bench, and about the optimal political timing of his eventual judicial resignation. We are moving toward a world where basically, even if judges don't pick other judges, you become a judge, a justice, within the judiciary, moving your way up through the system, and then you stay there. But that's not the early world. Justices are once former politicians, like John Marshall, he's the leader of the Federalist Party, Secretary of State, Congressman, or once and future politicians. They're actually going to be politicians, then go on the court. You're going to hear that about John Jay. In our century, Charles Evans Hughes, who's Earl Warren. He's a presidential candidate and ex-governor. Who's Hugo Black. He's an ex-senator. Very different world. Even in my lifetime, with people like Earl Warren and Hugo Black, than the world toward which we're moving, which is a little bit more one of judges moving up from within. Okay, so, but in the founding, good behavior, life tenure is not a life sentence, okay? People don't serve for life, in fact. For example, neither of America's first two Chief Justices served for life or anything close to it. Instead, John Jay left the bench after 6 years to become governor of New York, and Oliver Ellsworth quit after 4.5 years, timing his resignation in a manner that guaranteed that fellow Federalist John Adams would name his replacement. Together, these two chiefs spent only 10 years on the court and lived for some 40 years thereafter. In 1791, Associate Justice John Rutledge left the court for a government job in his home state, and Associate Justice William Cushing would likely have followed suit in 1794 had he bested John Adams in the contest for the governorship of Massachusetts. So he's running for governor while he's a Supreme Court justice. In the Republic's earliest years, judicial tenure during good behavior often simply meant until resignation. In 1787, this was the only model of judicial independence familiar to most Americans, a model that prevailed in 18th century England and in most of the newly independent states. Only New York had hit upon an alternative approach to judicial independence, featuring a long term with a fixed end date. In New York's case, tenure for good behavior until age 60, or you could imagine 15 years, a fixed Today, however, some version of this alternative model prevails in almost every American state and in most other advanced democratic nations. And for that democratic nations, I thank Mark Tushnet and Vicki Jackson for their excellent work on comparative constitutional law. So the federal constitution is virtually the only one, except Rhode Island, in the entire free world that has this good behavior model of life tenure. Others have fixed terms or mandatory retirement or some combination. Judges in these other regimes typically serve for relatively long fixed stints and or up to a mandatory retirement age. And I'm going to make now, this is the sting in the tail, the argument that arguably that's a better model of judicial independence, and here's why. This alternative model arguably does a superior job of insulating sitting judges from partisan politics. By giving each judge a fixed target date of departure, this model facilitates the emergence of informal norms whereby each judge is expected to serve out his defined term or give some nonpartisan reason, for example, personal health, for leaving early. So if it's 10 years, it really is a sentence and not just a term. By contrast, in a regime of life tenure, unless there exists a strong norm that each judge will in fact serve until death, there is no obvious target date of departure, no fixed and focal baseline against which to measure an early resignation. Thus, each judge remains more free to design his or her own individual exit strategy with a finger in the political wind and an eye on the political calendar. Well into the modern era, sitting justices have left the court for political pastures or have strongly considered doing so. It remains common for a justice to time his or her resignation so as to advantage the political party that named him or her to the bench. Nevertheless, modern judicial exit strategies have been less openly political than one might have predicted based on the early trajectory traced by Rutledge, Cushing, Jay, and Ellsworth. After these men, of course, came John Marshall, who profoundly changed the court simply by staying put, serving for more than 3 decades until his death in 1835. Just as Washington's unprecedented example of stepping down helped gloss the phrase 4 years, so Marshall's extraordinary tenure helped redefine the words good behavior. In the executive article, 4 years eventually came to mean no more than 8 years, while in the judicial article, good behavior generally came to mean far more than 8 years. The combined legacy of the early republic's dominant trendsetters, Washington, Jefferson, Madison, Monroe, who all stepped down after 8 years, and Marshall, who stays put, Virginians all, interestingly enough, was that the combined legacy, and here I close, was that presidents would renounce a norm of de facto life tenure while judges would embrace it. Thank you very much. Thank you. Sarah, what would you like to... Sure. Time for questions?
Do we have the microphones? We've got maybe 5 or 6 minutes.
Okay.
Anybody? Could I? Okay. Michelle? Wait.
You make the comment about George Washington being the unitary executive. It seems strange to me that he would take that position in light of my belief, and I'm not really sure where this came from, that George Washington was a reluctant server as president. It kind of runs contrary to the idea of a unitary executive. I wonder if you could comment on that.
George Washington's the greatest man in the world. That's what I was taught when I was 8 years old. Then in high school, because I had a great high school teacher, I learned about his feet of clay and his wooden teeth, and it's good to teach high school kids how to think critically, you know. And today I think George Washington is the greatest man in the world. I thought when I was 8 years old that my parents were the greatest parents in the world. Then in high school I had a different view, and now I think they're the greatest parents in the world. George Washington is the greatest man in the world because he steps down, because he has an army under his control, the only army on the continent, and he surrenders the sword to the Confederation Congress and goes home to his plantation, to his farm, Mount Vernon, and he basically says, "You'll never see me again. I'll just fade away." And so he is very reluctant to come back in because he's promised he's just going to go away. But his country needs him. The situation is collapsing. And so he is very reluctantly drawn back out. He is the unanimously selected president of Philadelphia. He's the unanimously selected president of the United States. Every elector votes for him, not once, but twice. And if he's going to do this, and he's going to be judged basically by his record, then he's got to have authority over his branch. Now he steps down again. And the reason he steps down, one of the reasons he steps down, you might say, well, why is he so trusted? One of the reasons he's father of his country is that he is not father of any of his own children. He has no dynastic pretensions. He's not going to create a throne because he's got no one to give it to. So of the first 5 presidents, Washington has no sons, neither does Jefferson, or at least any legitimate ones that we know about, Madison or Monroe. John Adams has a son, you see. His name is Q. And that's one and that's one of the reasons. And that's one of the reasons that Adams is seen as a monarchist. I have Boston newspaper saying explicitly, why does Thomas Jefferson, the man of the people, the guy lives on a mountaintop, owns 300 slaves, and he's the Democrat, and John Adams, a farmer's son, is the monarchist? Great PR job. Part of it, though, is, well, Adams says some silly things sometimes, but part of it is, and I got Boston newspaper saying it, vote for Jefferson, because like Washington, he has daughters and he can be trusted. John Adams has sons who will make themselves lords of the country. The 35-year-old rule is all about dynasty. The idea is, who's going to ever have the name recognition to be president age 32? A famous son of a famous father. And if you say 35, you've got to be judged on your own track record. Okay. Rather than just daddy's name. You can run, Q can run, but only after he's got a track record of his own. And it gives lower-born people a chance to show their stuff. And that person, and to understand this, you need to understand who's Prime Minister of England at the time. Anyone know who's Prime Minister of England at the time? Huh? Prime Minister. William Pitt, the younger, who is a member of Parliament at 21, Prime Minister at 24, and he might be good, he might be bad, but he's getting there because he's daddy's boy. And so George Washington says, and the question is whether Washington would have been as willing to step down if he had had a 30-something son saying, stay on a little bit because I'd like to succeed you. And we'll never know. But here's what George Washington does say about if he's going to do it. He doesn't want to do it. He's not really volunteering, but his country calls him, and good soldiers answer the call of duty when it comes. He wasn't behind the scenes trying to manipulate things. He got called, and so what he says is, okay, basically his view is, if I'm going to have to be responsible for this branch, then you have to give me power over it. These people are my assistants, and I've got to be able to monitor them because I'm ultimately accountable. He runs a coalition government with Jefferson as his left hand and Hamilton as his right hand, and in practice he favors his right hand. People are quite nervous about Hamilton because he's in effect they think of him as like the adopted son of Washington. He's got no father. Washington's not got no son. In fact, he was born in the West Indies, and Washington had actually been in the West Indies about the time of his birth. People say this. They express this anxiety in an Oedipal idiom, even though one guy's 6'3" and one guy's 5'6", you know. So there is this anxiety about him. But Washington has to be able to keep Hamilton and Jefferson in line. So here's what he says. As Washington saw the matter, executive underlings properly answered to him. This is a direct quote. The impossibility that one man should be able to perform all the great business of the government, I take to have been the reason for instituting the cabinet departments and appointing officers therein to assist the supreme magistrate in the discharging of the duties of his trust. So he's basically saying, you want me to do it, I'm going to be responsible, I'm going to be accountable after 4 years, and I'm going to be accountable to history. You've got to at least let me have control over my branch. If someone's not doing a good job, I have to be able to to fire them, and I don't need to prove that to you. The minute they lose my confidence, I have to be able to fire them. That's the so-called decision of 1789, that cabinet officials serve at the president's pleasure, which is a core idea of unitary executive thinking, which is affirmed by a very important Supreme Court case by a fellow here from Ohio named Taft in United States versus Myers in 1925. Let me finally read to you what Madison says in the first Congress. This sounds unitary executive to me. It is evidently the intention of the Constitution that the first magistrate should be responsible for the executive department. The Constitution affirms that the executive power shall be vested in the president. Are there exceptions to this proposition? Yes, there are. The Constitution says that in appointing to office, the Senate shall be associated with the president. That's confirming of nominees. Have we a right to extend this exception? I believe not. The Constitution has invested all executive power in the president. If the Constitution has invested all executive power in the president, the legislature has no right to diminish or modify his executive authority. Now, the real debate is not whether you have a unitary executive, but what powers that executive has. And that's a debate within unitary executive thinking. Unitary executive is not some weird fringe theory. The New York Times editorial page, to the contrary, notwithstanding. There's no lawyer on that page, and when they say it's a fringe theory, they just don't know what they're talking about. George Washington believed in unitary executive, so did Madison. The question is, what powers does that person have? Does they have a power to disregard the law secretly and not tell anyone about it? Well, that's not George Washington. That's not Lincoln. And here's the last sentences of Madison. Here's the question. The question now resolves itself into this. Is the power of removing a cabinet officer an executive power? I conceive that if any power whatsoever is in its nature executive, it's the power of appointing, overseeing, and controlling those who execute the laws. So, yeah, if you're talking about removing cabinet officials, that's unitary executive. If you're talking about supervising prosecution, that's unitary executive, says Justice Scalia in the Morrison versus Olson case. And I'm with him on this. Absolutely, constitutionally, 100%. If you're talking about violating laws secretly and not telling anyone, and then just when you're finally caught on it, saying, my lawyers, whom I appointed and whom I can fire at will, say it's okay for me to do it, well, that's not quite unitary executive.
I think this is another avoidance issue. Now, I actually have a serious conflict of interest because we're supposed to stop so that you get the privilege of listening to me in the next session, which I think is probably not the best deal that we could possibly make. But thank you very much. And thank you.